Conspiracy and proposal to commit felony. What do you understand by those terms? How do you define conspiracy? How do you know about proposal to commit felony? Good morning once again. I'm Attorney Alfonso Roma. I'm your instructor for criminal law, Book 1 of the Revised Penal Code, and today we'll be discussing conspiracy and proposal to commit felony under Article 8 of the Revised Penal Code. So going back to the question, what is conspiracy and what is proposal to commit felony? Now, conspiracy exists when two or more persons come to an agreement concerning the commission of a felony and decide to commit it. There are two or more persons. You cannot have conspiracy of one. Two or more persons come to an agreement concerning the commission of a felony and decide to commit it. The next question possible will be, is conspiracy alone punishable by law? Is there a crime for coming into an agreement concerning commission of a crime? Well, we will answer that later on. The next definition is proposal to commit felony. What is proposal to commit felony? Proposal to commit felony is when the person who decided to commit a felony proposes its execution to some other person or persons. So there is a proposal when a person who has already decided to commit a felony proposes the execution of said felony to some person or persons. So again, there are two or more persons involved in this. The one who originally decided to commit a felony and the other persons who were proposed by the one who decided to commit a felony. And you might also ask, is proposal alone to commit a felony a crime? Is it punishable by law? Now, to answer these questions, you have to look into the provisions of the law itself on Article 8 of the Revised Penal Code. And it states that, basically, it states that conspiracy and proposal to commit felony is not a crime in itself unless the law provides penalty therefor. So, conspiracy alone or proposal alone to commit felony is not a crime in itself unless there is a law punishing the proposal or punishing the conspiracy to commit crime. Now, you might ask, what are those crimes that conspiracy alone or proposal alone is punishable by law? The crime as provided for under Article 2 of the Revised Penal Code, well, conspiracy alone is already punishable by law are treason, codita, rebellion, highway robbery, sedition, illegal association, and espionage. In proposal to commit felony, the law itself provides penalty in cases of the same treason, codita, rebellion, and inducement not to answer the summon or appeal before the Congress. So, as a general rule, conspiracy and proposal alone is not punishable by law unless the law specifies crimes where conspiracy and proposal for those crimes are already punishable. Why is that? You might ask, why is that conspiracy and proposal alone, if not punishable by law, is not a crime? Well, those are preparatory acts, and without overt acts, without an act actually realize the crime, or the preparatory stage of the act is not the preparatory act is not passed upon, and there was no stages of execution being committed. So if you will remember the stages of execution, the attempted, the frustrated, and consummated stage. In cases of preparatory acts like conspiracy and proposal, the preparatory stage, which is not punishable by law, totally not illegal, is not passed, and the actor or actors, conspirators, or proponents did not commence to commit the crime which would touch on attempted stage of the crime. So conspiracy and proposal, as a general rule, is not punishable by law except those crimes that I have mentioned a while ago. In relation to the topic, what do you understand by implied conspiracy? Now, implied conspiracy is a conspiracy, of course, but you have to research the definition of that, or the meaning of that, or the explanation of that in implied conspiracy, and you may comment your answer on the comment section, and we'll check that, including your name and section, so that I will be giving extra points for the answers that you might be given on implied conspiracy. You have to research on that. Now, what if in conspiracy and proposal to commit a crime of robbery, for example, there was killing, or there was a serious physical injury committed by other members of the group? How do you charge each and every member of the group who committed robbery when there is killing, and the killing was perpetrated or committed by one or two members of the group, and the other members who went on to the act of robbery? How do you charge each and every member of the group who conspire to commit the crime of robbery? Now, as a general rule, and in following the jurisprudence laid out by the Supreme Court, as a general rule, all the members of the conspiracy, and the proponents, and the participants of the crime is liable for each act, or liable for every act committed during the existence of robbery. Now, for example, if one or two persons committed the crime of robbery, while the other, in while robbery is ongoing, committed the crime of homicide or serious physical injury, the crime committed by each one of them will be robbery with homicide or robbery with serious physical injuries, even though the other members, or one or two members, did not commit the crime of robbery. So what if member of the band, or member of the robbers, argue that he only agreed to the crime of robbery and not the killing and not the commission of serious physical injury. The reason for the Supreme Court on that is that in charging each and every member of the group on robbery with homicide or robbery with serious physical injury, the act of robbery and the killing or the resultant killing and serious physical injury is a natural and logical consequences of the act of robbery. So regardless of whether or not the participants all participated in the killing or in the serious commission of serious physical injury, they will all be liable for the crime of robbery with homicide or robbery with physical injury. How about now? You might ask, how about commission of rape? Now, the commission of rape is, of course, not a logical and natural consequences. But if the person or members of the group was present during the commission of rape but did not stop the same, they will all still be liable for robbery with homicide or robbery with yes, robbery with rape. The each and every participants of the crime will be liable for the crime of robbery with rape or robbery with homicide, even though there was no agreement as to the killing and there was no agreement as to the rape. The male presence of each and every member and they have the opportunity to stop the rape of the, or the killing because it was not agreed upon. They will all liable for the commission of rape or homicide in occasion of robbery. Now, it's the rule where the act of one is the act of all. The basic rule in conspiracy and proposal to commit felony. So I think that would be all on the topic on conspiracy and proposal to commit felony. You have to remember, as a general rule, conspiracy and proposal to commit a felony is not a crime in itself unless the law provides penalty for the act of conspiracy on those crimes I have mentioned a while ago. And general rule in in conspiracy or in the example I have given is that the act of all is the act of one is the act of all unless the person prevented the other commission, not other crime, not he agreed upon on. Yes, I think that would be all. And if you have questions, you might post it in the comment section or your answers on implied conspiracy. Thank you, and we'll see each other again later.